Hello there and welcome to yet another episode of Know Your Laws, where we talk on matters to do with law, justice and legal affairs to help you learn new laws that govern you. And today we are going to continue with our discussion on the law on alternative dispute resolution. Having discussed on mediation, tonight we discuss on arbitration. What do you need to know about arbitration and how does the application of arbitration go in the Kenyan law? I'm joined by my guest, who is Bruno Situma, an advocate of the High Court of Kenya. Welcome to the program, Bruno.
Thank you very much, Chris.
I just want us to begin the program at this point. Last time when we were discussing about the alternative dispute resolution of course, settling dispute out of court, we talked about mediation, but here comes arbitration, and we begin at this point. What is arbitration different from mediation?
You've said, I think last time when we were talking about the issues of mediation, one of the things that came out very clearly was the fact that in mediation, parties discuss and find their own solutions with the aid of a third party. Now, for arbitration, they take the same aspect of having a third party, but then they grant this third party the powers and the jurisdiction to make decisions on their behalf. Now, one aspect about it is that the decision that this third party makes on behalf of the parties is actually binding to both of them. So that is one aspect that majorly differentiates arbitration from mediation, in my view.
And now, having differentiated the mediation and arbitration, arbitration on itself, what does it mean, arbitration? Like in alternative dispute resolution, how can we define arbitration?
I will define arbitration as a method of alternative dispute resolution mechanism where parties enter an agreement, because most of these arbitration processes are governed by an agreement between the parties. So parties might find themselves in a situation where they have a commercial agreement between themselves that includes an arbitration clause. In that case, then they are saying that between the two of us, if any dispute arises between the two of us, then we will refer that dispute to a third party, and that third party will have the full powers and the full tenure to determine that particular dispute on behalf of the parties. So basically, arbitration is governed by an agreement between the parties, and those parties they devolve these issues between them to the powers of a third party, most of the time an individual.
Having talked about arbitration being a process that involves a third party, of course, it is a process of dispute resolution. So its application, right, in resolving a dispute, how does arbitration now get applied in terms of solving a dispute in a particular disagreement?
The first aspect that happens is usually the arbitrator will, first of all, I will start by saying that arbitration is governed by three aspects. The first one is usually the Constitution of Kenya. You remember I said that the issue of alternative dispute resolution mechanism is governed by the Constitution of Kenya. And then there is the Arbitration Act. So the Arbitration Act of 1995, together with, I think it was amended in 2010, and there is the Nairobi Center for Arbitration Act. Most of them are governed by what we call the UNICITRAL model, right? So that aspect governs international principles that lead to arbitration. And basically, it's well laid out in those acts. And in those two acts, the process of arbitration is very well laid out and very clear for the parties to follow.
Now, a well-laid process of dispute resolution, that is on arbitration. Of course, we understand there are different aspects of cases and disputes. Arbitration, what are some of the cases that can be used in arbitration?
We have mostly commercial disputes, right? And most of them are commercial disputes or cases involving parties from different jurisdictions. I think those are the most common that I have seen referred to arbitration. The other one that is gaining a lot of momentum in terms of being referred to arbitration are usually construction disputes. And part of the reasons why cases will be referred to arbitration usually is most of the time actually because of the complexity of the matters. So you'll find that if you put an arbitration dispute, if you put a construction dispute before a judge, sometimes they don't appreciate the nitty-gritties that come with construction, right? The judge is more aligned towards the law, right? But if you look at issues relating to arbitration, some of them are not even issues relating to the law. And for this reason, the parties then decide to say, let us refer this dispute to somebody who has the speciality of that particular field of work. So if, for example, we are dealing with business purchase, if we are dealing with taxation, if we are dealing with construction, like I've said, most of those things don't just require knowledge of the law. They also require knowledge of that field, perhaps engineering, quantity surveying, so that you're able to say, if this person brings this amount of, say, materials, then they will be able to conclude that house. So you'll find a lot of construction disputes. And as time has gone by, you get to a situation where several kinds of agreements, especially commercial agreements and construction agreements, they naturally place themselves in the ambit of arbitration by including arbitration clauses. I think those are the ones that come at the top of my mind very much, but a wide range of disputes can be referred to arbitration. Perhaps the only limitations that I would have to mind are disputes that involve criminal elements, right? So in that case, then, if, for example, you have a commercial dispute that has fraud and criminal elements to it, those could be quite difficult. But any other disputes could easily be referred to arbitration. Mm-hmm. Yeah.
And mostly because now arbitration is, as you've talked, is mostly used in resolving dispute in regards to commercial. In a case where there is a dispute between two companies and now arbitration has to come in, who decides on who to arbitrate, or rather, what does it take for them to finally agree on arbitration?
The issues, like I started by saying that, in fact, I would say the Arbitration Act sets out a very well-laid process of dealing with arbitration. So, for example, if I look at Section 12, Section 12 actually gives guidance, proper guidance to the parties on how to appoint an arbitrator. Sometimes the parties will include some of those clauses in the arbitration clause of an agreement. So perhaps they will say that they would appoint the chairman of the Chartered Institute of Arbitrators to appoint an arbitrator. Sometimes they will say that each party would appoint an arbitrator, and perhaps the two arbitrators would then appoint a third arbitrator. We have situations where parties even disagree on how to appoint an arbitrator. And in situations where they disagree on appointing an arbitrator, then in that case, they will refer the issue to the High Court for guidance on how they will go about appointing an arbitrator. Or if one of the parties, for example, appoints an arbitrator and the other one refuses to confirm the arbitrator, you refer, sometimes they might refer that to the court and say that if you don't give me, if you don't give notice to this party that you've rejected that arbitrator, then one of the parties could actually appoint an arbitrator unless the other one puts in very concrete reasons as to why that arbitrator will not be considered fair as a tribunal. But basically what I'm trying to say is that despite the laid down principles in Section 12 of the Act, parties still have leeway, because that is one of the objectives of arbitration, to give parties leeway to be able to determine a dispute in the manner that suits them best, but within certain laid out principles that are laid down in the Acts. Mm-hmm. Yeah.
And because you've talked about a well laid down process in choosing an arbitrator, let's talk about this case whereby we see a scenario where an arbitrator has been selected by one of the parties and the other party rejects. And of course, the party that has rejected doesn't inform the other party that they have rejected that particular arbitrator. Does the party that has selected the arbitrator have the jurisdiction now to proceed with the matter with the arbitrator of their choice?
One aspect about arbitration that really comes out very clearly is, despite the fact that arbitration is an open process for the parties to determine, there is also leeway to allow some intervention of the court in a few circumstances. And again, the good thing about it, like I'm saying, is most of these things are found in the Act. So in that case, then I will be looking at, or I probably will be looking at the provisions of Section 23, which determines situations where the court can determine, the court can interfere in certain limited circumstances. For example, one of the limited circumstances listed under Section 23 is issues relating to appointment of the arbitrator, right? So if parties have disagreed on the appointment of the arbitrator, then one of the parties can refer the matter to court and say that they are disagreeing with that appointment, like I've just said before, because of certain reasons. But one aspect that the Act also really points out is the Act provides that these parties, when referring these issues or when rejecting the arbitrator, must point out that either they have rejected the arbitrator from the onset, or that the arbitrator is not qualified according to the agreement, the arbitration agreement, because sometimes parties could say we want an arbitrator who is qualified in this manner, or that the arbitrator is not impartial for reasons. Sometimes the most common one is where parties are different nationalities, assuming you're Kenyan and I'm Tanzanian and you're appointing a Kenyan arbitrator, then I could say that there is perceived impartiality, or perceived impartiality could be created from that situation. But other than that, if one party refuses completely to engage in appointing an arbitrator, and the other one comes in late, the other one goes ahead and appoints an arbitrator, or asks for the chairman of the Chartered Institute of Arbitrators to appoint an arbitrator, then in those in certain circumstances, the other party who is refusing to engage could be stopped. To be stopped means to be prevented from, could be prevented from actually disputing that appointment. Yeah.
And can a party now decide that in the middle of an arbitration process that we don't feel like this arbitrator is bringing out the best of this arbitration process, and one of the parties move to reject that particular arbitrator? What happens in such a scenario?
I would say that once parties bind themselves to arbitration, and the arbitrator has been appointed, it is almost impossible legally for either party to then say that they want to walk out of the arbitration process, because one aspect about the arbitration process is the moment you get in, then you waive. There is a principle that says that the parties then waive the ability to then dispute that process, right? And I'm trying to put it in the most possible, in the easiest way to understand. So I would say that once a party binds itself and the arbitrator gets to work, then perhaps only the arbitrator can walk away from that table and say, I don't want to handle these issues for this and these reasons. But it will be very difficult for parties to then create a situation where the arbitrator where they walk away from the table because they feel that the arbitrator is not being fair. Yeah, that is quite difficult. But one aspect that I probably need to add very quickly is that, you know, the decisions of the arbitrator are binding, right? And the fact that they're binding means that the appellate process in an against an arbitration award is also very limited. There is the grounds upon which a party can rely on to set aside the award of the arbitrator become very limited. But one of the things that a party can rely upon to set aside an arbitration award is if they can prove that either the arbitrator was impartial, right, or that the arbitrator exceeded the powers that they were given. So if a party feels that the arbitrator is not acting properly, right, they can hold on to that and say, let's wait and see what comes out of the whole process. But then that could be a proper ground or a very strong ground for appeal for the award to be set aside by the High Court. And it's among the very limited grounds upon which an award can be set aside.
So in such a case where you have grounds to reject the arbitrator or the arbitration process, the dissatisfied party,
yes,
where does he or she go to is it to the High Court, and what transpires for the High Court once that submission has been made that we have rejected this particular arbitrator because of sufficient grounds that is not able to complete the arbitration process?
What usually happens is the issues relating to setting aside an arbitral award are very limited, and again they are listed out in the Act, right? So the grounds upon which an arbitral award can be set aside could include things such as if the award is against public policy, right? So they look at it and say that if we allow this award to be enforced by the other party who was victorious in the arbitration, or who got the arbitration award to their favor, right? If you allow that to be enforced, then it will be against public policy. That the public would then look at it and say, or some people, the public will look at it and frown upon that kind of conduct, right? Number two, they would say that if, like I said previously, shortly before, if the award if the arbitrator acted beyond their powers in awarding that, so they were supposed to probably just determine certain issues, but they went ahead and determined issues that were not placed before them for them to determine, right? And the third one usually is if it can be proved that the arbitrator was impartial, right? That he did not act in a manner that is neutral and partial between the parties, then you can set that aside. But you notice that section, the grounds are usually set aside in section 35. And notice that those grounds are very limited. So you cannot come and say that the arbitrator, for example, did not consider my evidence, right? Or did not agree to what I told him. Unlike appeals in normal mainstream cases where you can literally appeal on anything and everything that any grounds can be grounds of dissatisfaction. Assuming you say, I feel like these guys did not take my evidence, they did not consider the weight of my evidence, those ones are clearly not within the ambit of an application to set aside an arbitral award. And of course, like you say, that is usually to the High Court. There has been a lot of jurisprudence back and forth as to whether you can appeal after the High Court makes its decision, either to set aside the award or to enforce the award, as to whether you can appeal to the High Court and whether you can appeal to the Supreme Court. Because one thing they say is that part of the reasons why parties engage in arbitration is to get what we call a finality of the award. So they say once the decision is made by the arbitrator, there should be very limited litigation after that. Otherwise, it will defeat the purpose of engaging in an arbitration.
You know, of course, it's a long process, and it's a very civic process where it involves parties in terms of arbitrating parties that are in dispute. And assuming now they have come to an agreement, that an arbitrator has reached a final agreement and said this is a way to resolve the dispute between the disagreeing parties. Does that arbitration agreement or ruling by the arbitrator be adopted by the High Court, or what happens to enforce such an agreement?
Now, once the arbitrator has made their award, right, and they have basically then determined the issue in favor of one party or another, what the parties have to do is you have a period of 90 days to appeal to set aside the award if you are dissatisfied, right? If you are the one who got the award in your favor, you can enforce that award anytime, right? But most of the time, what we do as lawyers is to say, if this person still has 90 days within which to appeal to set aside this award, or to make an application to set aside this award, it will not make sense for me to try and enforce it tomorrow, right? Because then in that case, they still have that period to set aside the award. So most of the times, you'll find that where there is an arbitral award, the parties, the advocates who are successful in the award would wait for 90 days and then make an application to the High Court so that that award can be enforced. But again, even the issue of enforcement, because one of the things that comes with arbitration is you could find a situation where enforcement is actually supposed to be done outside the country. And that becomes an entirely different process, because the process of enforcement of awards outside the country is very different. You have to first of all determine whether that country has what we call a recognition agreement or not with Kenya, and then the process that sets out after that will follow. Because if the country has a recognition agreement, the process is different from a situation where the country does not have a recognition agreement. And some of those things are a bit technical, right? But one aspect that I would say, to just put it simple for the viewer to understand, is once you get your award, you must go to the High Court. For Kenyan awards, you must go to the High Court to have and make an application for it to be enforced. Now, in that process, then once the High Court grants your application, you follow the normal process of execution against the other party.
In a case, now you've talked about enforcing international arbitration agreement. In a case where there's a disagreement or rather a dispute between an international party and a local Kenyan party, and there's a dispute, of course, and then there has to be an arbitration process. Do they consider the Kenyan law in coming up with the arbitration agreement, or do they consider the foreign law of that particular other party's country in coming up with the arbitration agreement?
That's a good question, because it brings me to one of the advantages of having arbitration. Now, when it comes to the arbitrator, you've asked, one party is international, another one is Kenyan. In fact, if that situation arises, sometimes that will be one of the best situations to refer to an arbitrator. The reason for that is because then the arbitrator can juggle between the laws, or at times perhaps disregard both laws and concentrate on the factual issues, right? And then find out the best decision that suits both of them, right? If the agreement was, say, governed under Kenyan law, those will be things for the arbitrator to consider. If the agreement was governed under foreign law, those will be things for the arbitrator to consider. But nothing actually prevents the arbitrator to determine that one issue is governed by foreign law and the second issue could probably be governed by Kenyan law. So, for example, I'm looking at a situation where it's a sale of goods contract, right? Sometimes the issue could be governed by, the contract could actually determine that any issues will be governed by this law. And in that case, then the arbitrator will be bound in that situation, right? Or the contract could be governed by the country of origin, right? Yeah. So, or we could have an influence that comes as a result of the goods being exported to a third country, right? So, in that case, what the arbitrator does is the arbitrator reads the intention of the parties. In summary, reads the intention of the parties and is able to determine from the intention of the parties who entered into the agreement or the conduct of the parties what law would actually be applicable. So, I think that's it. Unlike, for example, if you go to court. If you go to court and you are an international party against a Kenyan party, the courts will say we do not have jurisdiction to handle or to determine issues regarding foreign law, right? So perhaps you might be pushed to a situation where you're taking Kenyan law. And that becomes one of the advantages of having arbitration, that it allows parties to juggle between foreign and local law. Yeah.
And now, as we conclude, my final question will be, once there is an agreement about a dispute by the parties and each of them gets the agreement, the final bit of this program I want us to talk about, can the High Court reject that particular agreement by any arbitrator in case one party moves to appeal about the agreement?
Yes, if one party moves and makes that application to set aside the award and the High Court is satisfied that those principles set aside in Section 35 of the Act have been met, then the High Court will not hesitate to set that aside. But one thing that I know, or from the way it has happened practically, is sometimes that situation of setting aside the award opens more of a Pandora's box than it helps resolve the issue. Because then one of the parties moves to the Court of Appeal and seeks for leave to appeal against the High Court. And then the Court of Appeal will determine whether the other party sometimes even says the Court of Appeal should not be interfering with the decisions of the High Court, they're supposed to be final. And the whole cycle continues. There is one case that has been the core of that Pandora's box. It's called Newto Agrovet versus Airtel. It has gone all the way to the Supreme Court. And most of the things that were being determined, or most of the things that were being discussed in that case were issues related on whether you can appeal against the High Court's decision to set aside the award of the arbitrator. Because sometimes, of course, the intention was that it becomes final. If you go to the High Court and you expect enforcement, right, I should be able to enforce, but if I appeal also to set aside, you should be able to agree that the High Court has made its decision. But the nature of arbitration is not that. That is not what happens in normally, yeah.
And just at that point is where we wind up this particular discussion on arbitration. Of course, having known that the viewers understood what arbitration is and the process itself, and that is where we wind it up. Thank you so much, Bruno, for making time to have this discussion.
Thank you very much for hosting.
And that is where we make a point of concluding our discussion on arbitration process here in Kenya. Last week, we talked about alternative dispute resolution, and we also majored on mediation. You can be sure to check out that episode on our social media platforms at YouTube, KAK TV Kenya, at Facebook, at KAK TV Kenya, and that is where we wind it up for always making time for this particular program. My name is Chris Sambu. Goodbye, and see you on the next episode.
Losing a beloved one can be one of the hardest life experiences. Death brings a total change in many setups, the family taking a huge position. Death also provides an opportunity to celebrate the departed and their achievements on earth. KAK TV provides for you an opportunity to announce death and funeral